The great state of Texas is an at-will employment state. That leaves very little options to an employee. If a certain number of 20 or 15 or 50 employees, depending on which statute, exists, you do have a lot of rights under federal law. Without a written agreement, though, you can be fired at will. If your employer comes in and says, you know, you're the best employee I've ever had. You're loyal and you've given me 17 years, but you've got a pimple right here on your nose, and I've hated that all 17 years, you're fired. There's nothing you can do about it without a contract in this state. There are, however, federal laws that give rights to employees. If you're fired because you're disabled and not given an option for other possible positions at a firm that will accommodate your disability, if you're fired specifically because you're old, if you're fired specifically because of your race, if you're fired because of your sex, you are entitled to compensation, and you should see a lawyer and get legal redress. Now, these federal rights are very restrictive in most situations. You've got to do it quickly. EEOC filings require 180 days from the date of the commission of the act. It's a pretty hard deadline. In fact, it's an absolute deadline in 99.9% of the cases. So if that is the case, you need to see an attorney and get a procedure established. If you have 15 years of discrimination, but you're not discriminated against in any way for 2 years, and then you're fired, you had 180 days from the date of commission of those acts to bring your lawsuit. At the end of the day, unless you have a federal proceeding under one of these acts, you need a contract. And I'm well aware in a recession how difficult it is getting an employer to do a contract. But if you are upper middle management, if you are in possession of certain very important information or a really unique skill, ask for a written contract. Put a term on the contract. I don't care if it's just 6 months, 3 months, 2 years, put a term. Put with your compensation, your benefits, your vacation time, your sick days, your maternity issues. It might be very useful if there's not enough employees to come within federal guidelines. Then, if you're terminated, you have a right for recovery, unless it's for just cause. Just cause is a term that's been interpreted by about 1 million different cases. You have to speak to lawyers specifically to see if they have a defense to a wrongful termination. Another possibility is that exempts at will defenses is if you are asked to commit an illegal act and you were terminated specifically because you will not commit an illegal act, you're entitled to wrongful termination damages. Now, what can that act be? It can be forging documents, kickbacks, false claims. Usually, Sarbanes-Oxley, accounting, fraudulent entries, a number of different items, actions, conduct, which are illegal and which you're told, we need you to do this. If you don't do it, you're going to lose your job. With or without a contract, if you're working on commission on a bonus plan and you have an agreement for that and you have accrued rights and wages and consideration under that agreement, and it's an at-will contract and you're terminated, you are still entitled to what you earned up to that date, whether you have a right to not be terminated or not. You may want to see an attorney because you're still entitled to your sick days, vacation days, personal days, and other remuneration under your oral agreement, whether you have a defense to being fired or not. And a lot of times for independent reps, for salesmen, for brokers, folks who work on commission, you may have earned significant commissions, royalty, or other income that you're entitled to. And no one's at will to deprive you of that. I would urge you to carefully consider, if you're an employee, signing any document that contains an anti-competition clause. The law changes on this issue about like the wind blowing. Right now, it's very strict. If you don't have a good, solid basis at law, that covenant is going to be upheld. Even if it says you cannot sell widgets anywhere in the world for 100 years, you will get a reformation of that law. Most courts will reduce that egregious clause to a reasonable space and time. Dallas and Collin County, a year and a half, instead of the whole world forever. But it doesn't help you much if you can't eat during that period of time, and if you're paying lawyers in an adjunctive proceeding to even have the right to work. Regrettably today, employers use these agreements at will, and they are mostly enforceable for the large part, and everybody has to work, and sometimes you feel like you're almost extorted in signing them. But unless it's a very good job that you trust the employer and the company is not going to go broke in your mind, don't submit yourself to that type of tyranny with regard to the right to work and earn a living for your family.
Nacol Law Firm, may I help you?